Welcome to the Bar Exam Toolbox podcast. Today, as part of our Listen and Learn series, we're discussing the Federal Rules of Civil Procedure, and particularly FRCP 12B. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoyed the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we love to hear from you. And with that, let's get started. Hello, and welcome back to the Listen and Learn series from the Bar Exam Toolbox podcast. Today, we're discussing the Federal Rules of Civil Procedure, and specifically Rule 12B. This is a very important rule that governs defenses and motions to dismiss, and it is frequently tested both in civil procedure classes and on the bar exam. Rule 12 in general is about defenses and objections, and 12A sets out the procedure for filing a responsive pleading, including the timing of when the answer must be served. We're going to focus primarily on Rule 12B, which lays out certain specific defenses and provides guidance on when they must be asserted. 12B starts by saying, every defense to a claim for relief in any pleading must be asserted in the responsive pleading if one is required. What this means is that if you are the defendant, you need to assert all of your defenses in your answer. But the specific defenses enumerated in Rule 12B may also be asserted in a separate motion, that is, a motion to dismiss. These defenses are 1. Lack of subject matter jurisdiction, 2. Lack of personal jurisdiction, 3. Improper venue, 4. Insufficient process, 5. Insufficient service of process, 6. Failure to state a claim upon which relief can be granted, and 7. Failure to join a party under Rule 19, that is, failure to join a required party. A motion to dismiss based on any of these defenses enumerated in Rule 12B must be made before filing your answer. Some of the 12B defenses can only be raised in an answer or a motion to dismiss, while others can be raised at later stages of litigation. These distinctions are set forth in Rule 12H. Under Rule 12H, lack of personal jurisdiction, improper venue, insufficient process, and insufficient service of process are all defenses that must be raised either through a motion to dismiss or in the first responsive pleading, aka the answer. Otherwise, they are considered waived. So let's say that a defendant files a motion to dismiss for lack of personal jurisdiction, and that motion is denied. Can she then raise improper venue in her answer? No, she cannot. Because she already filed a 12B motion to dismiss and did not raise improper venue at that stage, she has waived her right to assert that defense at a later point. By contrast, a defendant has more opportunities to raise a defense for failure to state a claim upon which relief can be granted, or for failure to join a required party under Rule 19. These two defenses can be raised in the motion to dismiss or in the answer, but they can also be raised at trial, even if they have not been raised previously. These two defenses are not waived until trial is over. The final defense referenced in Rule 12B is lack of subject matter jurisdiction. While this defense can be raised in a motion to dismiss, or in an answer, or at trial, it is never waived. It can be asserted all the way through the appeals process, even if it wasn't brought up earlier. If a court determines at any time during the proceeding that it lacks subject matter jurisdiction, the court must dismiss the action. So always remember that it is never too late to raise the issue of lack of subject matter jurisdiction, because that goes to the very heart of the court's ability to rule on the case. A lot of these defenses, like improper venue or insufficient service of process, are fairly self-explanatory, and others, like subject matter jurisdiction and personal jurisdiction, have been covered in other episodes. So for the next few minutes, we're going to focus now on what is arguably the most complicated of these defenses, which is 12B6, failure to state a claim upon which relief can be granted. So what does that actually mean? Failure to state a claim upon which relief can be granted means that the plaintiff's pleadings has not sufficiently presented her claims. So what is required in a pleading in order to survive a 12b6 challenge? The requirements for a pleading can be found in Rule 8a, which provides that a pleading is adequate if it contains a short and plain statement of the claim showing that the pleader is entitled to relief. The basic idea of a 12b6 motion is that the moving party is claiming that the plaintiff's complaint has failed to show that they are entitled to that relief. At the pleading stage, the parties have not yet gone through the discovery process, so there's a lot the parties still don't know. Even so, even at this stage, there must be enough information in the complaint to persuade the court that the party is potentially entitled to the relief that they're seeking. The 8A standard of a short, plain statement of the claim might seem pretty easy to satisfy, but in reality, the court's evaluation of the pleadings for the purposes of a 12b6 motion can be a pretty difficult standard for plaintiffs. Today, a court's analysis of a 12b6 motion is guided by two important cases, Bell Atlantic versus Twombly and Ashcroft versus Iqbal. I hope I'm saying that right. Together, these cases tell us that a complaint must paint a plausible portrait of the alleged activity. It's not enough that the allegations made in the complaint are consistent with illegality, because the court can consider alternative explanations in making its assessment. In evaluating whether the complaint has successfully stated a claim upon which relief can be granted, the court will only consider the factual allegations, not any conclusions that are drawn. So before evaluating the complaint to determine whether it states a claim upon which relief can be granted, the court will first strike any conclusory allegations, instead looking only at the facts. The facts provided at this pre-discovery stage must be compelling enough on their own for the court to believe in the plausibility of the claims. So to break that down into how a court will actually evaluate a 12b6 motion, first, the court is going to strike all conclusory allegations from the complaint, leaving only the facts alleged by the plaintiff. Then, taking all factual allegations as true, the court will determine whether the complaint makes a plausible case that the plaintiff is entitled to the relief sought. In undertaking this second step of the analysis, the court has a good deal of discretion in asserting whether the plaintiff's story is a plausible one. Now that we've covered the basics of Rule 12b, let's look at our first example. Jane had worked at a Fortune 500 company in State A for more than a decade. She was well liked by her peers and supervisors and was considered a likely candidate for an executive position that had recently become vacant. Her coworker Marcus was also interested in the executive position. Shortly after the position became available, Marcus began telling other employees at the company, including several who sat on the hiring committee, that Jane had been embezzling money from the company. Marcus received the promotion, and shortly thereafter, Jane was let go from the company. Jane filed an action against Marcus in the U.S. District Court for the District State of A. The complaint alleged that Marcus made defamatory comments about her to other employees at the company, thereby committing a tort under State A law. In particular, Jane's complaint alleged that between August and September of that year, Marcus had repeatedly made remarks to coworkers and supervisors that Jane had engaged in dishonest, even criminal behavior. The complaint further stated that such comments were false and defamatory. Marcus has moved to dismiss the defamation claim, arguing that Jane failed to state a claim upon which relief can be granted. Let's focus on the 12b6 analysis. Under Rule 8a, the pleading of claims in federal court tells us that a pleading is adequate if it contains a short and plain statement of the claim showing that the pleader is entitled to relief. In Twombly and Iqbal, the Supreme Court interpreted Rule 8a to mean that the plaintiff must allege, at a minimum, facts that state a plausible claim for relief, not mere conclusory allegations. Jane's complaint appears to satisfy this pleading standard. She alleges that Marcus made comments to the effect that she had engaged in dishonest or criminal behavior. She alleges that such comments were false. Her complaint provides the approximate dates when the comments were made. Such comments, if made, would likely be defamatory under state law and would state a plausible claim for relief. Now let's look at another hypo. John, a citizen of California, was driving through Arizona when he was hit by a drunk driver, Eric, a local business owner and citizen of Arizona. John sustained serious injuries from the accident. John sued Eric in the United States District Court for the District of Arizona. John's complaint invoked the court's diversity jurisdiction. The process server attempted personal service on Eric, but Eric was out of town and couldn't be located. Instead, the process server left the summons and complaint tucked under the doormat at Eric's business. 72 hours later, when Eric returned to work, he found the papers. Eric filed a motion to dismiss John's complaint for failure to state a claim, and the district court judge denied his motion. Eric subsequently filed a second motion to dismiss for insufficiency of service of process. The judge also denied that motion. Did the court properly deny Eric's motion to dismiss for insufficient service of process? Explain. Although it is likely that service of process was improper in this case, the district court nonetheless was correct to deny Eric's motion to dismiss on that basis. Eric initially responded to plaintiff's complaint by making a motion to dismiss for failure to state a cause of action. When that motion was denied, Eric moved to dismiss for insufficient service of process. As we discussed earlier, if a party makes a Rule 12b motion and fails to join other available defenses, the party waives those other defenses and is not allowed to raise them later. So if a party makes a 12b motion but fails to include the defense of insufficient service of process in that motion, that defense is deemed waived. Because Eric has made a 12b motion to dismiss for failure to state a claim, but did not join his available defense of insufficiency of service of process in that motion, Eric waived that defense. So the district court was correct to deny Eric's motion to dismiss on that ground, regardless of whether service was in fact improper. Well, that's all we have for you today. Hopefully you found these hypos to be helpful examples of how to work through a motion to dismiss question on an exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.